Whether a person is defending themselves or another person, or defending property in their possession, the general rule will be that they can undertake any acts for the purposes of protecting or defending property or a person as long as they reasonably perceive a threat and their acts, including their use of force, are reasonable in the circumstances.
However, in many cases, defense of property soon turns into defense of person. If my home were invaded, a home invasion sort of by definition has that added dimension of bodily harm or threats are being done to the occupants of that home. There is that element of personal violence. So then it would be quickly defense of self as well as defense of property, and the reasonableness is determined in the circumstances of that event.
We'll call the meeting to order. We're a little bit late because there was a vote in the House. It is the meeting number 18 of the Standing Committee on Justice and Human Rights, and joining us today is the Honourable Rob Nicholson, Minister of Justice, and Mr. Nicholson has a couple of people from his office, Ms. Kane and Ms. Kleinberg, and we'd like to welcome you. And my understanding, Minister, is that you can't be here any longer than 12:30 because of other appointments?
Exactly, Mr. Chairman. That's
so we understand that. And if you have an opening you wish to address the committee on, Minister, please go ahead.
By all means, and thank you, Mr. Chairman. I'm pleased to appear before this committee to present the Citizens Arrest and Self-Defense Act. This legislation aims to do three things. Number one, expand the time in which a citizen may arrest another citizen for an offence or in relation to property. Two, replace the existing laws on self-defense with a new and simplified defense. Three, similarly replace the existing laws on defense of property with a new and simplified defense. Les membres de ce comité sont sans doute au courant des...
Committee members are doubtless aware of recent incidents where citizens used force against individuals that they suspected had stolen from them or damaged their property.
Of citizens' arrest, these cases have also generated confusion about the relationship between citizens' arrest and defense of property, which itself is closely associated with the defense of self-defense. These three mechanisms share common elements and arise in similar fact situations, which is why our government is presenting all three in Bill C-26. They typically come before the courts as defenses where a person has done something that would otherwise be an offense, but they did it for the purpose of apprehending a suspect or defending property or a person. Each provision reflects a different purpose for acting in emergency situations. The bill's proposal to change the law of citizens' arrest is straightforward. Subsection 4942 currently permits a property owner or a person in lawful possession of property to arrest a person they find in the act of committing an offense on or in relation to that property. Currently, this provision does not allow for the arrest of the suspect even a short period of time after they were detected committing the crime. This bill will allow more flexibility in the timing of an arrest. Specifically, it would amend Section 4942 to allow a person to arrest another within a reasonable time of finding the suspect committing the offense. Some stakeholders may express concerns about the risks associated with permitting more arrests by citizens and the possible encouragement of vigilantism. I agree that wherever possible, arrests should be undertaken by trained law enforcement officers, but we know this may not always be possible. I'm confident that the expansion of the citizens' arrest powers will not lead to vigilantism. Indeed, the approach on C-26 sets out a reasonable compromise. It extends the period of time for a citizen's arrest, but any delay must be reasonable. And this power is itself limited to the narrow set of cases involving crimes on or in relation to property. In addition, before making use of the extended time period, the arresting person must believe on reasonable grounds that it's not feasible in the circumstances for a peace officer to make the arrest. The existing law also requires the arresting person to turn over the suspect to police as soon as possible. These safeguards will help to ensure that individuals who make a citizen's arrest are involved in law enforcement only to the degree necessary, and that the police maintain their primary law enforcement function. Arrests are dangerous and unpredictable, and our government will continue to urge Canadians to leave this job to professionals whenever possible, and in every case to exercise extreme caution. In terms of the defences of property and person, the bill replaces the current multitude of provisions which are largely unchanged from the original text enacted in 1892, and actually they had a pretty extensive history before 1892. These are basically the provisions that were contained in the laws of Upper Canada in or about 1840. We have replaced those provisions with a simple, easy-to-apply rule for each defense. For decades, criminal practitioners, the Canadian Bar Association, the Supreme Court of Canada, academics, and many others have criticized the law of self-defense primarily, but also the law of defense of property as being written in an unnecessarily complex and confusing way. The complexity of the law is not without serious consequence. It can lead to charging decisions that fail to take into account the merits of the defenses in particular situations. It can confuse juries and can give rise to unnecessary grounds of appeal which cost the justice system valuable time and resources. The law should be clear and clearly understood by the public, police, prosecutors, and the court. Le projet de loi.
The bill, C-26, meets these objectives. It sets out and simplifies the code without sacrificing the existing legal protections.
These are the same and can be easily stated. Whether a person is defending themselves or another person, or defending property in their possession, the general rule will be that they can undertake any acts for the purposes of protecting or defending property or a person as long as they reasonably perceive a threat and their acts, including their use of force, are reasonable in the circumstances. There are some special features of each defense that I would like to briefly mention. In respect of self-defense, an additional feature proposed in this bill is a non-exhaustive list of factors to help guide the determination of whether acts taken for a defensive purpose are reasonable. Clearly, what is reasonable depends upon the circumstances of each individual case. However, a number of factors commonly arise in self-defense cases and are familiar to the courts. For instance, relevant considerations include whether either or both parties had a weapon and whether there was a pre-existing relationship between the parties, in particular one that included violence. Proportionality between the threat and the response is also highly relevant. The greater the threat one faces, the greater the actions one can take to defend against that threat. The list can be employed to facilitate and improve charging and prosecution decisions. In court, the list will no doubt be a useful reference for the judge to use in instructing the jury. A list as this also indicates to the courts that existing jurisprudence on these issues should continue to apply. We don't have to start from scratch. The right to defend oneself from threats is fundamental. It's therefore tremendously important that we get it right and that we provide guidance as we shift from a highly detailed set of laws to a defense based on more general elements. Now, with respect to the defense of property, the defense of property has as its core the same basic elements as self-defense, namely a reasonable perception of a threat, a defensive purpose, and actions that are reasonable in the circumstances. However, the defense of property is necessarily more complex than self-defense. There are many different types of property claims and interests, most of which are governed by provincial laws. Property concepts are implicated in the defense. The idea of peaceable possession of property is an additional condition for accessing the defense of property. This term is used in the current law and has been interpreted by the courts to mean possession that is not subject to a serious challenge or that is not likely to lead to violence. For example, a thief who stole property and is not in peaceable possession of that property and cannot legally use force to defend his possession. That makes sense. The criminal law prioritizes the preservation of the public peace and the status quo. The law protects possession, not ownership. Ownership disputes must be resolved by the civil courts, not through criminal action. The law permits what would otherwise be a crime to defend against emergency threats that risk permanent loss of or destruction to property. As a final note, I draw your attention to the fact that both defenses contain a special rule in relation to their use by someone who claims to be defending against law enforcement actions, such as an arrest or the seizure of property pursuant to a warrant. The rule is this: unless the person reasonably believes that the peace officer is acting unlawfully in discharging their duties, defensive force may not be used in this context. Bill C-26 is consistent with the current law in these situations, but hopefully, and I believe it does, express the law more clearly. I encourage the members to support this legislative package, which aims to allow citizens more latitude in arresting individuals they have seen commit an offence on or in relation to property, and to bring our laws of self-defense and defense of property from the 19th century into the 21st century. Thank you.
Thank you, Minister. And now we begin the rounds of questions, and we begin with Mr. Harris. These rounds are all 5 minutes, so for questions and answers. Go ahead, Mr. Harris.
Thank you, Chair, and thank you, Mr. Minister, for joining us today. We welcome the attempt to clarify the law of self-defense, and I call it that because I guess what our job is to have a good look at it and try to ensure that it does result in clarification and not another series of decades or whatever of court interpretation. On that score, is there are you satisfied that setting forth the examples, for example, in 34.2, the factors that it's a non-exhaustive, as you pointed out, list of factors to be considered, that the current case law, as it exists over the last 100 years, will still be useful and valid in helping to determine what's reasonable in terms of self-defense, and that, in fact, all it's doing is clarifying the application of that?
I think that's exactly what it does, and you've made a very good point. What is reasonable has been before our courts for quite some time, and that jurisprudence will continue to be of assistance. But as you point out, even with the non-exhaustive list that's contained within this bill, this is something, in my opinion, that is long overdue. I've heard from law enforcement agencies that when they deal with these sections, and it doesn't matter whether you're a lawyer, a member of the public, the courts, I've heard law enforcement agencies point out that it's very complicated, these defenses, and I remember a comment from one individual who says, we're better off just letting the courts figure this out. I said, well, no, this is not what we want to do. I mean, if it's not necessary or not appropriate to lay a charge, we don't want to have that happen. It's not just something, just throw it to the courts and let them figure out these provisions, which are largely unchanged for the last 172 years. And so, like so many different sections of the criminal code, I think it's appropriate for us to have a look at this, try and clarify it, but as you say, with the benefit of decades of jurisprudence as to what's reasonable and what's not reasonable.
One of the things that this proposed amendments do is not make what the current code makes a distinction between the amount of force allowed to be used to protect a dwelling house, a home or real property, and greater force is permitted there than to defend a movable property. That distinction is removed.
Yes.
Do you think there will still be a distinction in terms of what level of interpretation, in terms of what you can or can't do when you're trying to stop someone from grabbing your purse as opposed to having someone invade your house?
I think it clarifies the law to the extent that some of those distinctions on legal ownership and exactly what type of property, which is all through the existing law that we have there, basically clarifying it so that if you're, it's not just a question of defining whether, okay, is a mobile home a home, is that the same thing as real property and all that. And as I say, I think many of those distinctions were unhelpful in terms of trying to figure out whether these sections apply and whether a person has acted reasonably under the circumstances. And so a more general application, I think, is appropriate rather than getting into all the possible distinctions of property ownership that are possible under our law.
One final question, and we'll explore this later, but was consideration given in looking at the changes to the self-defense provisions in particular to the series of some pretty high-profile cases where spouses, victims of spousal abuse, have in fact killed their spouses and raised the self-defense as an issue? As you know, these are complicated and sometimes controversial cases. Was special consideration given to ensuring that the changes in the law would still give rise to the defense of self-defense as it has been determined by the courts right now?
I think you've raised a very good point, and that is certainly one of the valid considerations in putting this together. And you'll notice that in that non-exhaustive list that the past history of the relationship between the individuals. So in the cases of the type that you're talking about, where, for instance, an individual has been a previous recipient of violence from the individual that is approaching him or her, that's another consideration to be taken into the course in terms of the level of reasonableness. And so, again, it's not just a coincidence that that particular provision is put in there. Again, it's a non-existent list, but we wanted to make that clear, that that previous relationship that, as you point out, in some circumstances involve violence and threats are part of that as well for consideration. So it's a good point.
Mr. Gauguin.
Thank you to our witness, Mr. Nicholson, and to his associates to be here. I'm sure your clarifications will help us understand the bill better.
The protection against crime to the public, and clearly Bill C-26 does not alter that. Some people have argued that perhaps the changes brought by C-26 might encourage an atmosphere of vigilantism. Could you provide us with your thoughts on this?
I don't think so. Again, if you look carefully at the section on citizens' arrests, as I'm sure you are doing and will continue to do, we indicate that the person who can take advantage of that, or the person who's actually witnessed and has actually seen this, that they haven't got it from second or third hand that a crime had been committed and then they're getting involved with citizens' arrest, that they must be there present to see the crime committed, but within a reasonable period of time after that, they apprehend the individual. So I think it was very carefully crafted in that regard, because I'd be concerned that if a person believed that somebody had committed a crime at any time or anywhere and actually hadn't witnessed it themselves, we might lead to the situation that you described. So again, it's very careful. I don't expect any increase, quote, of vigilantism as a result of this. And as I say, it's carefully crafted, but it expands the ability of an individual who has been victimized or witnessed a crime of this type to be able to do something about it. But again, as you know, and that's part of the provision as well, that you are to turn this individual over to a law enforcement agency as soon as possible, and I think that's appropriate. This is what we want.
And obviously those who feel like they should express some vigilantism will be subject to the full expression of the laws against them.
Again, vigilantism is not something that we've ever encouraged in this country, and certainly this bill doesn't do that either.
Wondering briefly about the issue of reasonable force. The defense of property does not explicitly spell out what limits should be placed on reasonable force. Obviously, this can extend all the way to lethal force. How can we determine exactly what is reasonable in the circumstances?
Well, as you know, and you practiced law in this country, and that term reasonable shows up in inside and outside of our laws. It certainly is a major component of the common law of this country, what is reasonable under the circumstances. And again, those tests that have been applied in our courts for a couple of centuries now will be continued. So they will look at each case and see what is reasonable under the circumstances. But I'm just pleased that we've finally updated the laws, and so to make it a little more comprehensible. And again, we don't just do these things for lawyers or the courts. We do them for the people who have to administer these laws. And as I say, I've heard this again when I get together with people in law enforcement, and again, many times this wasn't the first topic they talked to me about. I might have been there for something else, but then they raise this and say that this is overly complicated and difficult. And you know, even as a lawyer, you look at all those different sections, and you can say this isn't easy. And as I say, it's I think in part a function of when it was originally drafted.
Just wondering about the issue of lethal force. Certainly, I mean, one can contemplate that perhaps lethal force in the defense of oneself or others might be contemplated, but do you draw a line between the use of lethal force for self-defense versus the defense of property? Does that strike any difference in your mind?
Well, we do. We do a distinction, and this is why we don't just combine this into one section. As you see, there is the section on self-defense, which is something different than the defense of property. And again, what is reasonable under each circumstances can be different. And as I say, you've underlined and given me that opportunity to say that. And so there was no consideration in drafting this that we would put both of these together and just say what's reasonable. No, there has to be a distinction with if you're protecting yourself or your loved ones from injury or harm. There has to be a distinction between that and the defense of property. And that continues in this legislation.
Thank you, Mr. Gauguin. Ms. Sgro?
Yes, thank you very much, Mr. Nicholson. A couple of years ago, I had a constituent call me that had someone was breaking into his home, and he attacked the individual in self-defense, defending his home and his family. Well, his wife called 911, but consequently at the time, of course, he was charged as well as the intruder into the house. Under C-26, how is that going to make
I'm sorry,
different?
in your fact situation?
Yeah, the individual
he
was defending his own house and property, which is much of what C-26 is talking about. But ultimately, he still had to hire a lawyer and go through the process when he was defending his home and family.
Yes.
Under C-26, how is that going to be different?
Again, I never comment directly on any particular case that's before the courts or any fact situation. I'm satisfied that what this law will do will clarify the circumstances under which an individual is entitled to defend their property. Distinctions as to either ownership or how much possession you had unnecessarily complicated the defenses of self-defense and the defense of property. And so for me, this was an easy sell when I was shown this and how it was difficult. And I quoted you the one law enforcement agency said, let the courts figure out, well, the individual who should not be charged and the individual who has acted reasonably to protect themselves, as you say, protect their house or their family, we don't want them in court in the first place. I mean, this only adds to the clogging of our courts. It's an additional expense to litigate these matters. We don't want to go there if the person has acted reasonably. And so I'm satisfied that the clarifications of this law will address fact situations similar to the type that you're given to me without commenting on any specific case.
Well, thank you. Under the new Section 34, the distinction between provocation and intention to use deadly force will not be as explicit. How and will that have any effect on the battered women syndrome? Will it still be open to accused persons?
I would point out it's a different issue with respect to, for instance, if there's provocation or something, that's something completely different. But I might ask Joanne Kleinberg, who is an expert on this law in this area, comments.
I believe the section you're referring to, which sets out what provocation may look like for the purposes of self-defense, that would not be part of the new law on self-defense. I don't think that's actually a provision that's invoked very, very infrequently. I'm not aware of any cases where it's actually been an issue in terms of a battered spouse type of situation. So its removal certainly wouldn't have any impact on that particular situation. And the presence of that provision really only serves one function, which is to determine whether self-defense would be available under Section 34 or under Section 35. And by collapsing all of the multiple self-defense provisions into one single, more generally applicable provision, there really is no need to have anything that sort of defines what provocation would be. It simply would become a factor to consider in determining the defense overall, but it wouldn't be determinative of anything.
And one last question, if I can get it in there. Why is gender referred to in this legislation where it isn't referred to in the criminal code anywhere else?
Again, size, gender, age, all these things play into whether a person has might have acted reasonably. So you could have an individual who was 6'6" and 250 pounds, and another person who was 5'1" and 110 pounds. And again, these are the kinds of things you want them to take into consideration, whether they're in terms of who's acted reasonably and who has used a reasonable amount of force. So those are just a number of factors just take into consideration, that's all.
Okay. Thank you very much.
Okay. Thank you. Ms. Boylan.
Thank you, Mr. Chair. It's always interesting to look at this. I remember my classes in criminal law. This was one of the most interesting components for law students to study, because there's quite a bit of subjectivity and objectivity, and finding the right balance in this is not always easy. My colleagues have touched on the issues that I was going to raise, but I just want to make quite sure about something. When you put in the new criteria in a new clause 34.1, was that as a result of a nomenclature of all the criteria that had been set out in the case law? My concern is this. When defense lawyers look at the changes to the legislation, obviously they're going to be looking at case law as examples of grounds for self-defense, the criteria that are used, because it is based on existing case law. But are we sufficiently reassured that we've reviewed the situation so that we don't end up having certain defenses where people say, well, that had been argued successfully, it wasn't picked up again by Parliament? Does that indicate that that's not a reasonable ground? I don't know if you see what I'm trying to get at here. Have we really looked at all the criteria? It doesn't mean that there's an exhaustive list. There may be other things that come up over the years, but compared to the past and existing case law, has that been done?
Very good point. It is not intended to supplant existing jurisdiction, and I think you're quite correct that what is reasonable under the circumstances will continue to be argued, and past cases would be a good indication of just what is reasonable or is not reasonable under the circumstances. You point out something else as well. We deliberately put the list to be non-exhaustive because, as you say, you want the law to develop. There may be other criteria or situations here that we're not exactly aware of or may develop in the future. And so we don't want to close it off and say, well, you didn't come within Section 2 through H, and so therefore you're out of luck in trying to use the self-defense provisions. But so the list is a non-existent list, but again, again, this is not intended to supplant existing jurisdiction, because you're quite correct. We don't want to be clogging up the courts and taking up the time to go over areas that have already been decided, that have already been adjudicated on. But much of what we are doing in this law is just clarifying so that it's not overly complicated for any individual or person or agency or court to figure out just what we're talking about when we're talking about the defense of a person or property.
Excellent. Aussi, dans la section...
In addition, the section I'm most concerned about, I'm always concerned. Well, I don't even know how you say this in French. Vigilantes. It's always a concern for us when we see people taking justice into their own hands with the dramatic consequences that can result. My concern is this. In proposed clause 312, it says any individual and anyone who is authorized. Who are we referring to when we the owner or a person in lawful possession of property or a person authorized by the owner may arrest without a warrant? I've got a problem with this, or a person authorized by this person, and that can be done within a reasonable length of time. Isn't that a bit vague? Reasonable length of time. Isn't that a little bit vague? I'm having trouble understanding that. And the more vagueness there is, the more room there is for the defense to bring forward all sorts of arguments. So I'd like some reassurance on that, please.
With respect to the citizen's arrest, that we provide a little more clarification and an expansion of the category of individuals who may conduct a citizen's arrest. Obviously, the first person you think of is the owner or the person in lawful possession. But it may be, for instance, a business may have employed a private security guard. So they're in lawful possession, they are there, and we don't want to exclude an individual like that who sees somebody committing a crime and they then initiate the arrest. So it's not just a question of the person owning the property, it's the person who is authorized by the owner or the person in possession of the property.
So it could be an employee. It could be an employee of a depanneur or something like that.
But in terms of your comments about vigilantism, you'll see that we don't go the next step on and say that anybody who believes that somebody has committed a crime anywhere can then exercise the citizen's arrest. We're not saying that. They're saying if you are one of come within that category, as we've described, if you see somebody, if you become aware of somebody committing that crime, then you can, within that reasonable period of time. So that catches the, it includes the case where if you saw somebody committing a crime and then you ran into that person an hour or two later, then it seems to me that's within reasonable time. And you'll notice that we can include those provisions, say that where it is unreasonable to get a peace officer to effect the arrest, that has to be a part of it. And we don't want you imprisoning this individual. We want you to turn this individual over to law enforcement agencies as soon as reasonable.
Okay. Ms. Finley?
Thank you, and thank you for being here, Minister Nicholson, Ms. Kleinberg, and Ms. Kane, to assist us this morning. As you outlined, Minister, in your earlier remarks, Bill C-26 makes it a requirement that the arrestor find someone committing an offence, and that is, arrest has to be effected at the time of the offence, and also that an arrest occur within a reasonable time. I'm curious as to your comments as to why our government decided not to adopt the opposition party's proposed private members' bill's test of reasonable grounds to believe that an offence has been committed.
There were a couple of versions that were introduced in the previous Parliament with respect to citizens' arrest, and we had a close look at all of them when we developed the government's legislation. It seems to me that we are better off confining it to individuals who are witness to the offence themselves. Again, I've had, just since I've been here this morning, on at least 2 different occasions from 2 speakers, the question of vigilantism. And again, there's nobody wants Canada to go down that road. We have confidence in law enforcement agencies in this country. We want to work with them. But we know that an arrest by somebody in law enforcement may not be always feasible, may not be able to be timely, and so we want to have these provisions. To have a situation where anybody at any time, because they reasonably believe an offense had been committed somewhere at some time, to be able to arrest an individual, I think that would be a huge expansion of the citizen's arrest provisions. And again, I don't think that is justified, and I think that to have it more focused on situations that do arise where people see somebody committing a crime, I think this is the best compromise in terms of that. So again, we look at all these issues, but it was time to have a look at citizen's arrest and to change those provisions so that if you caught somebody out in the alley 3 hours later, that there's no question about that, that again, if you're acting reasonably, you witnessed the crime and it's within a reasonable period of time that you've got that, and those other qualifications. As I say, I think that is a good fit for this. So we weren't trying to expand this into some other area that I think would be quite foreign to the people of this country.
Okay. I was also wondering if this legislation, do you believe, would prevent incidents like the 2009 arrest of Mr. David Chen for kidnapping after he detained a shoplifting suspect? I know that he received an acquittal ultimately, but my understanding is that one of the issues that figured into Mr. Chen's case was the period of time between the commission of the offense and the arrest, and that resulted in the kidnapping charge. So.
Again, I don't get into the particulars of any exact case, but I have heard, though, from law enforcement agencies that they find the whole area very complicated and is not as helpful, quite frankly, as it should be. You will note, though, in the legislation that we have, first of all, we've corrected the problem with respect to the timeliness of the arrest by putting the reasonable period of time. But you will notice as well that there are provisions within here that you have to only exercise this right when it is unreasonable or unfeasible to have somebody in the law enforcement community do this, so that we don't have because people doing this on themselves unless it's necessary, because these are inherently dangerous situations here, and we don't want people to unnecessarily hurt themselves and get involved with something much more serious than what they are trying to correct. And so I think that is a reasonable provision to put into the criminal code, as well as the provision that you must, within a reasonable period of time, turn that individual over to law enforcement agencies. We don't want to have a situation where people have some sort of a right to detain someone or imprison someone. That's not the role of an individual citizen. After they've effected a citizen's arrest, it's to turn that individual over to law enforcement agencies as quickly as possible, and that is what is preserved and made explicit in this piece of legislation.
Thank you.
Thank you. Mr. Jacob.
Oui, bonjour, Monsieur le Ministre.
Good morning, Minister. I have a few questions about the implication of C-26 on private security firms. My first question, will the changes suggested in C-26 change the activities of security officers in broadening the provisions with respect to citizens' arrest? Are we opening the door to possible abuse on the part of security officers? And 3, should we subject security officers to more restrictive rules to limit their powers so as to distinguish between ordinary citizens and merchants?
Mr. Jacob, you'll notice that in our definition of who can exercise these responsibilities or these can act on these occasions that are presented to them, that we've clarified the laws with respect to that individual. It's not just the owner of the property or people who have a certain right or a title. We've made it clear that the person could be authorized by the owner or the people in possession of the business or the property, and that certainly would include private security agents. I think if you ask them, I think you will find that they are quite satisfied with that, and I would go so far as to say they would be pleased with the fact that they will come within the definition that is existing within this particular piece of legislation, so that if the person has been given this legal responsibility to protect the property, they can exercise the same the rights as the owner would. And so I think you'll find that those provisions within the Act would be, as you see, Section 3.2, the owner or a person in lawful possession of property or a person authorized by the owner or by a person in lawful possession of the property may arrest, etc. So, again, I think you would find from people who are in that business, I think that they will favorably look at this and say, look, this actually sort of clarifies what can or what can't be done, and that it obviously includes us. I wouldn't want to be any more specific. I wouldn't want to start identifying, say yes, but if you're a private security firm, you are okay you'll come within the definition of this, because once you particularize those definitions, you'll find that somebody else who is reasonable under the circumstances taking that role isn't included in it. And this is why when in questions to my answers to Madame Boivin, I said it is a non-existent list that we've got here in the front part of the bill, and there's a reason for that, because if other situations develop in the future, we don't want to say, oh, now we have this gap in the criminal code that it's not covered. And so when we draft these, we try to draft them not just for what we are facing today and the challenges that we have, try to draft it in a way that it will encompass future incidents similar to the type that we are addressing today.
Thank you, Minister. How much time do I have left, Chair? A minute? 494.3 says that someone who's just arrested someone, that he be handed over immediately to a peace officer. I would like to know how much time are we talking about here exactly? And outside major centres where there are fewer police officers, is there more time to turn the person over to a police officer? If we don't set a timeline for turning people over to peace officers, might there not be a danger of this vigilantism?
Specific. I mean, if you're in downtown Toronto, if you didn't turn over an individual for 24 hours, most of us would probably agree that that would be unreasonable. Okay? You could be in parts of this country where it's not feasible to get somebody, a law enforcement agent there, that 24 hours might be may not even be enough to get somebody. Remember the RCMP or whoever is involved with law enforcement. So we deliberately don't specify that. We don't put rules that would be applicable in Toronto but would be unreasonable somewhere else in the country, or have a test that works very well, for instance, in Canada's north, where someone from law enforcement may not be readily accessible, and then say, oh, that would be reasonable in downtown Toronto. No, we don't do that. I think we're better off leaving it, say, okay, what is reasonable under the circumstances? In my example to you, if you arrest somebody here in the city of Ottawa, for you to try and make the case, I didn't turn the guy over for 3 days, to the police, that would be very difficult. And my guess is the courts would say that's not reasonable, that doesn't come within the definition. But you could be someplace, you could be in a remote community in Nunavut and say, look, we couldn't get anybody in here. It was unfeasible to have somebody from law enforcement here within 24 or 48 hours. And I think a court then would say, yes, that is reasonable under the circumstances, but we want to make the point and the case here that whatever that reasonable test is, we want you to turn this individual over to law enforcement agencies. We're not in the business of having people imprisoning, Canadians, on their own initiative and detaining them. Say no. If you witnessed a crime, you've arrested this individual, turn him over, whatever him or her over, as quickly as possible.
Thank you, Minister. Mr. Jean.
Thank you, Mr. Chair, and thank you, Minister, for appearing today. My interest is also in the situation of reasonableness and using force in the circumstances. And I know that currently the use of force to protect property in one's possession is the current wording, but would a person be able to undertake self-defense by using a firearm? I know in the past, in some cases in Alberta, people have continuously come onto property, stolen quads or stolen personal property of an individual, more than one or two people, and people have used firearms, shot in the air or shot around the people. Would that be a reasonable use of defense in the circumstances?
I think it is. I mean, every case is decided on its own, but the individual who has people, for instance, coming onto their property, stealing or destroying, or trying to take possession of their property, the individual who wields shows a firearm. Again, it's what is reasonable under the circumstances. If somebody is trying to steal your notebook, you don't have a right to shoot that person because that is obviously and patently unreasonable. But again, I get asked this, on a regular basis, what is reasonable? I mean, what was the test? Was it the man on the Clapham bus or something? Whatever he thought was reasonable would be the test. Well, we have to apply those tests, and answer to Monsieur Jacob, I pointed out, okay, most of us can figure out what's reasonable. What's reasonable in a remote community in Nunavut in terms of turning that individual is not the same test for reasonableness if you're in downtown Ottawa. You see, so again, it's the appropriate language that has served us very well, and it turns on the facts of every situation.
In fact, wouldn't it be fair to say that much of the criminal code and the tests used have not been changed since 1892, some of them, and in fact the test of a reasonableness and a reasonable person actually changes based upon society?
You've made a very good point, okay? If you were doing your thesis on the whole question of the tests of reasonableness, there has been the jurisprudence has helped define that, and what was reasonable in 1840 in Upper Canada when these provisions were basically were written, there'd be much different tests today to what is reasonable than it was 172 years ago, but nonetheless the reasonableness test has worked. But you're quite correct with respect to the criminal code. We have an obligation, the criminal code, to continuously to have a look at it to make sure that it reflects societal needs. I made the point here when I was here on auto theft. I mean, there are, it was pointed out to me by the Attorney General of Manitoba that there are specific provisions for stealing a cow, but no specific provisions for stealing a car. Well, I remember at the time I said, I promise we're going to change that. Not the part about stealing the cow, that's still an offense. But it's reasonable to have section with respect to auto theft because, again, that reflects what's happening in society, and we have to make sure that the criminal code, just because there were no cars when the criminal code was enacted in the 1890s, doesn't mean that it's not a serious matter for us today, and that's why we continuously try to have a look at these. And part of what we're doing is updating the laws with respect to the defense of property and self-defense.
Now, I understand in some states it was actually a hanging offense to steal a horse, but I won't go into that.
No.
I'm sure it's not anymore in Canada. In fact, I know it's not. I'm wondering about another situation that arises from time to time, which is obviously a situation that needs to be discussed by judicial means in deciding cases, but oftentimes people will be continuously broken into, and from time to time people have set traps in their home through windows, through doors, that sometimes have a fatal conclusion. Sometimes have a situation of maiming a person. Now, would that be considered something of reasonableness?
Well, again, it reminds me of being back in law school. I mean, the individual who had dug a pit, you know what I mean? They had people trespassing on his property here, and, you know, the next person went and dropped, you know, 25 feet down into some sort of a pit, whether that was reasonable or not. And I mean, it wasn't reasonable when I was back in law school 3 decades ago, and it's, you know, it's still not reasonable today. Again, the test of what is reasonable under the circumstances, as you've quite correctly pointed out, has changed over the years, but it's again what most people would feel would be appropriate. I mean, we all have, you know, or many of us have alarm systems in our homes, and we try and take precautions, but, you know, having booby traps that in your case could maim somebody, again, I think most people would conclude that, you know, that's not reasonable under the circumstance. You might have somebody delivering pamphlets or something that you didn't want to see, and again, you know, we can't have that kind of situation. Did you want to add something, Ms. Kleinberg?
I would just add that there is actually an offence in the criminal code for trap setting where there is the likelihood of causing bodily harm. Typically, the traps will be set in advance of there being a particular threat, and so they wouldn't be temporally connected enough with the threat that could justify the use of force in self-defense.
Thank you, Madam Board.
Oui, merci.
Thank you very much. My first question. Was the new bill where we allow the courts to take into account a list of factors? I would like to know this. What's the reason for giving people an opportunity to look at the list or not? And why would we put this in as a mandatory requirement?
In my answer to some of the questions, and so we didn't want to confine the list and say that's it, this is the list, because the first argument would be, of course, is that if somebody was charged, oh, you didn't come within the definition of Section H, and so therefore, you know, that this defense is not open to you. It may be circumstances that haven't been contemplated yet in jurisprudence, or situations that may develop in the future that put it into a slightly different context. I mean, we deal with this all the time. I mean, when you for instance, if you look at the criminal code, it you know, refers to, you know, telephones and, you know, and as you know, that's not the only way of communicating anymore. If you sat down 45 years ago, I mean, basically that's it, and telegrams and all that. Well, again, we know that people don't send telegrams to each other anymore, that there are hundreds of ways of communicating, not necessarily by telephone, and so I think we're better off if we write the criminal code in a way that doesn't confine it to what is reasonable or what may take place in the future. You would want, and you probably agree with me, if on this list, if there were other legitimate reasons why an individual was using force to protect themselves, you'd say, well, yeah, that's reasonable, but we wouldn't want to get caught by the fact that they only proposed a closed list back in 2012 when they wrote this particular section of the criminal code.
Okay. Merci.
Thank you. My second question now. Since we're going to allow people to make citizens arrest when there are reasonable grounds for doing that, my question is this. Could we allow someone to use criminal profiling? This person looks like a criminal. Are we opening the door to criminal profiling?
Why, you know, these have to be very careful. You don't want to be stereotyping, and you don't want to be subjecting people's opinions to prejudices, that sort of thing. So, no, I don't think that would be appropriate. I mean, one of the provisions, as you'll notice in self-defense, is the previous relationship. I mean, if an individual knows this individual to be violent, or they've been the subject of the violence themselves, that seems to me that adds to the reasonableness of them to take steps to protect themselves from an individual such as that. So it is a non-existent list, but no, we can't and should never get into the idea of sort of profiling people, strictly on the basis of some prejudice that an individual may have. We don't want to go there, and this is why the bill is carefully drafted so that, yes, okay, it may be more reasonable for you to take steps if you have been a victim of violence from this individual, but again, in the absence of something like that, we have to be very, very careful. And so, again, we can't start, and nor can we legislate, people ability to claim a protection because of their either stereotypes or their prejudices against any particular individual or group.
We've come to the end. Thank you, Minister. I think we're just about dead on the time that we had available. And my understanding is the two officials will be able to stay with us for a bit longer, and there may be some questions. So although you'll leave, I think we'll have adequate answers here for any other questions we may have. Okay, Mr. Rathgaber, we have the two officials are going to stay with us, and as soon as they're ready, if you have any questions from the officials, please go ahead. 5 minutes.
Thank you, Mr. Chair, and thank you to the officials from the Department of Justice for your expertise with respect to this important matter. Following up on some questions that Mr. Jean asked with respect to sort of the limits and how broad a net C-26 will cast with respect to providing defenses. I'm curious as to your thoughts with respect to the existing laws. I understand it. Self-defense is limited to justifying acts of force. But if I can have you think outside the box, one can think of a situation where an individual might be in a position where they might have to take evasive action to avoid an attack, and perhaps in the course of that evasive action, I don't know, they might steal a car. So that would be an act that was otherwise illegal, but in the context, they are doing it in self-defense. And I'm curious what your thoughts might be as to the applicability of C-26 to that type of situation.
That is actually one of the ways in which the language on that particular issue will be changed by Bill C-26. So the multitude of provisions right now, they do limit the responsive actions of an accused to, in various formulations, necessary use of force, no more force than necessary. But it is all premised on the use of force. And so one of the things that Bill C-26 does is precisely in recognition of the fact that there might be other evasive actions that a person would take in a threatening circumstance, where those actions could potentially be criminal in ways that don't involve the application of force on another person. So the wording that's in Bill C-26 does talk about the act that is committed is reasonable in the circumstances. So the language of use of force would be replaced with more general language, which does permit, as you suggest, for instance, breaking into a house to escape someone. Now, it's likely the case that actions like that could be used as a defense under the current law, potentially under the common law defense of necessity, which self-defense sort of works as a subset of the defense of necessity. But I think the thinking was that if the purpose is really to protect yourself from a threat that another person is launching against you, that it's more appropriate to conceptualize that conduct as self-defense as opposed to the defense of necessity. So that does account for the expansion of the language in this respect.
Thank you. Mr. Dean and I both come from Alberta, and there have been some high-profile cases in Alberta in the last couple of years, specifically in rural Alberta, where law enforcement is some distance away, and where events have occurred on private property,
and chases ensued off private property, and individuals ended up getting involved in some criminal activity. I'm not going to ask you to comment on those specific cases, but what I'm concerned about is, and I do support the legislation, let's be clear on that, but the short title, Citizens' Arrest and the Defense of Property and Persons, might give some level of comfort or assurance falsely to individuals who might want to engage not so much in vigilantism, but in perhaps defending their property to an extent which is not contemplated by this Act. So my question is, what type of educational campaign does the Department of Justice envision to educate Canadians on the somewhat narrow parameters appropriately that this bill will provide protection for the defense of property?
That's a very valid point, because we do want Canadians to fully understand the law and its limits. So our intention would be that when this Act is proclaimed into force, that it would be accompanied by the appropriate, whether we call it a technical background or a fact sheet or whatever, that would clearly delineate to Canadians the changes in the law and the limits on that law, so that whether they are relying on the defense of self-defense or defense of property, or whether they are wanting to know more about the law of citizens' arrest, that they would know that we're not encouraging vigilantism, that the first line of recourse is always to law enforcement, and that where you're defending your property, you have to do only what's reasonable. The common law has made it clear that defense of property alone does not justify the use of deadly force, so we would want to make that clear. And that in all other cases, we're looking at reasonableness in the circumstances and perhaps provide some examples and so on. And to the extent possible, we would make that available in user-friendly language for distribution to relevant stakeholders.
Thank you, Mr. Chair. Those are my questions.
Mr. Harris?
Thank you very much, Chair. I just may pick up on that last point, because I think to the previous laws, I talked on the policy side with the minister, did make a distinction between movable property and real property or dwelling houses, and said specifically that you couldn't cause bodily harm in the defense of movable property, and then had a different rule for preventing the invasion of your house, that you could use as much force as is necessary to prevent someone from invading your property under Section 40. And now, you said that you wouldn't think it would be reasonable to use deadly force in defense of property, and you used the word generally. And I agree. In fact, Australia, we've been told, has a rule that says you cannot use lethal force in defense of property. And we did have a rule that said you can't use you can't use bodily harm in defending against movable property. Someone's trying to steal your purse or whatever, you can't stab them. Those have been left out of this, and it's one thing to say, well, we all know what reasonable is, but we don't all know what reasonable is, and we may have very different attitudes. There may be different attitudes in some parts of the country than in others. There may be different attitudes among some people than others, and at the end of the day, it's going to be a judge or a jury deciding what's reasonable in the circumstance. And I'm a little concerned about the lack of guidance that this provision actually gives. Can you tell us why you left that out, and why you made no distinction between someone having their home invaded, for example, and someone having their purse snatched?
I can begin to answer, and my colleague will likely elaborate further. Just so, in case I misstated something, the point that I was making was that with respect to defending property alone, it's the position of the common law at present that you can't use deadly force just to defend your property. And we have not changed that in this current these proposed amendments. However, in many cases, defense of property soon turns into defense of person. And as you've noted, in every case, it's going to be a situation of the judge looking at what exactly transpired in the particular circumstances of the case. So if my home were invaded, a home invasion, sort of by definition, has that added dimension of bodily harm or threats are being done to the occupants of that home. It's not just my home is invaded without me being there, because then that's a break and enter or robbery. But there is that element of personal violence. So then it would be quickly defense of self as well as defense of property, and the reasonableness is determined in the circumstances of that event, whether there's violence being used against me, violence being used against my children, whatever. But Joanne Kleinberg is best positioned to indicate why we're not going down the road of identifying whether it's a movable property or a dwelling house or others, and we're going with one simplified provision that will adapt to the circumstances.
Right. So there's just a little bit more detail I can add, which is you're exactly right that Section 38, which is one of the defenses for protection of movable property, doesn't allow very much force to be used to defend that possession. But Section 39, which is another defense that exists for a person to use to defend their possession of movable property, the difference being in the case of Section 39, the person who's defending the property has a claim of right to the property, which is an element that's actually missing from Section 38. And if you look at Section 39, it's not limited in the same way that Section 38 is limited. It talks about this person is protected from criminal responsibility for defending that possession, even against a person entitled by law to possession of it, if he uses no more force than is necessary.
Well, that's part of the confusion in the existing law. I recognize that, yeah.
That's right. So, but I think the key thing to take away is that even at present in the criminal code, with respect to protection of movable property, the law is not limited only to very minimal force. So if we were to introduce a rule, we end up pretty quickly back in the same sort of situation which the objective of simplification is seeking, which is a variety of different rules depending on the circumstances. And so really it's the objective is to simplify, and while I think the objectives the Parliament had back in 1892 when they enacted the multitude of provisions was laudable, they were actually trying to address finely nuanced distinctions between different types of circumstances. But the problem is, in practice, it just leads to really complicated jury instructions and difficulties, as we know, for the police in applying the law. So simplification, unfortunately, requires a level of generality.
I have a technical question on a word that's used there, and we're not going to have a chance to talk to these officials who drafted the legislation. Well, I wasn't, but I had no control over how long they spoke.
Will you give him a...
Thanks very much.
Your colleague across the table.
I have a question on the wording chosen in Section 34(1)(b), and it appears also in the proposed Section 35(1)(c) as well. And it says, the act that constitutes the offence is committed for the purpose of. Well, this is all about a person who's not guilty of an offence, so how could you use the term, the act that constitutes the offence is committed for the purpose of? I'm not an expert in legislative drafting, but I wonder if some consideration should be given to changing that to the act that would otherwise constitute the offence, or the act that gives rise to the charge, or something like that, because the act that constitutes the offence is a bit of a tautology there. It assumes that it is an offence, and you're really talking about a defence, in which case it wouldn't be an offence. Anyway, that's the lawyer in me, and I'm sure some other lawyers sitting around here might have the same question if they looked carefully at it.
That's a very valid point, and this was it's a neat little problem to solve from a legislative drafting perspective. And it seems to be that oftentimes in the code we do use the language of the act that constitutes the offence, even in circumstances where it's not an offence ultimately at the end of the day that a person is going to be criminally responsible for. There may in fact be better words which don't lead to a sort of legal conflict in the nature of the language. However, we are quite confident that the courts will not be confused by what this language means, and that in practice it won't diminish what it is the defenses are seeking to provide.
Thank you. Mr. Wilkes.
Thank you, Chair. And I'll bring out the policeman side in me now. I'm just curious with regards to this bill, does it also cover off when a police officer directs a civilian to apprehend an individual, and to how much force can be used in that circumstance?
Perhaps could you elaborate on the scenario that when a police officer would be directing somebody else to apprehend?
I'm sorry.
Could you elaborate on the type of scenario you have in mind when a police officer would be asking a civilian to apprehend someone on their behalf?
Sure. Let's use Section 68 of the Criminal Code, where a proclamation has been set out with regards to rioting. Mm-hmm. A number of police officers show up at a scene, overwhelmed, direct A to apprehend that person and do what you need to do to keep him in custody.
Well, if the person A has found another person committing an offence, but it's not in relation to their property, so I don't think that scenario would be covered by what we're contemplating in the citizen's arrest context, because we're only changing the law with respect to the person's property that they are affecting the arrest, loss or damage to property.
So we're also dealing with apprehension, though, are we not? Not just of property. So I guess what I'm getting at is that a lot of police officers from time to time, including myself in my previous life, will utilize the opportunity, if need be, to have a citizen make an arrest on my behalf because I was detained at the time doing something else, but saw a crime occur. I saw the crime occur. So now I'm going to direct that person to make the arrest.
Well, that conduct is, I think, still covered by Section 494, subsection 1 of the Criminal Code, which is not being changed by Bill C-26. We're only changing 494, subsection 2, which deals only with the citizen's arrest in the property context, fines committing an offence.
Okay, thank you. Mr. Chair, one more quick question, if I may, with regards to what I always was under the understanding from the perspective of a police officer is you may use as much force as is necessary. Mm-hmm. So is that going to be the term under 494 sub 2?
Section 494 sub 2 adopts or cross-references to Section 25 of the Criminal Code. So it's the same standard of force. I'll just go back to 25 to get the proper wording. So Section 25 refers to somebody who is doing anything in the administration of the enforcement of the law, whether it's a private person, a peace officer, public officer, to assist a peace officer, a public officer, and if he acts on reasonable grounds, justifying in doing what he is required or authorized to do, and in using as much force as is necessary for that purpose.
Thank you.
Okay, that brings us to the end of the agenda. As members will see, there is some committee business. I'd like to thank the witnesses for being with us today. I think you've provided us with a clarification of a number of the issues, and I think the committee obviously will go forward being well armed with the information. Thank you again.
Perfect.